Okay, we're live.
Okay, thank you. All right, so we are back in Senate institutions and we are hearing testimony on S69, an act relating to age-appropriate design code. And now we have Dr. Jenny Radesky, Associate Professor of Pediatrics, University of Michigan Medical School. So thank you very much for being here, and we look forward to your testimony.
Thank you. I appreciate the opportunity to speak here today in support of S69. I am a tenured associate professor of pediatrics. I direct the Division of Developmental Behavioral Pediatrics at University of Michigan. So I practice as a developmental pediatrician, seeing kids with developmental delays, ADHD, autism, behavior problems. I also run an NIH-funded research lab. We focus on mobile and interactive media, family relationships, child social emotional development. And I have a particular focus on digital designs that monetize children's experiences through ads or purchase pressure or data collection or designs that prolong their use. I'm also co-medical director of the American Academy of Pediatrics Center of Excellence on Social Media and Youth Mental Health. In addition, for the past 8 months, I have served the U.S. Federal Trade Commission on a part-time basis as a behavioral expert. So I just want to make clear my testimony today reflects my expertise as a researcher, does not reflect the views of University of Michigan, American Academy of Pediatrics, Federal Trade Commission, or any of the commissioners. So what I want to describe in my testimony today is one, the different types of online harms to minors and their prevalence. Two, how they're caused by a combination of problematic designs, data profiling, and also the ways children are different developmentally and those vulnerabilities, how they interact with those designs. I'm not going to focus a lot on content because I think it is harder to regulate around content, but designs are a really important opportunity for creating a safer digital media ecosystem for kids. I'm also going to talk not only about social media, but also about gaming platforms. So there's really global consensus that online harms to minors exist. I'll provide a written form of this testimony where I list out all the different ways that the OECD, the World Economic Forum, the National Academies of Science, the US Surgeon General, the Interagency Task Force on Kids Online Health and Safety, they have all released reports in the last several years that agree.
I'm sorry, doctor. I'm sorry. You used an acronym, and the first thing that you
yes.
What was the acronym?
That's Organization for Economic Cooperation and Development, OECD.
Appreciate it.
So I'm going to lump these harms that have been described in all of these prior reports into 3 broad categories. There's contact harms, which we've heard about already, about contacts from people who are harassing or bullying or sextortion. There's privacy and profiling harms and how that affects young people, and emotional well-being harms. Okay, so first with contact harms, there's cyberbullying and harassment. This has been reported by nearly half of US teens and 60% of teens who play video games. Bullying is facilitated by a few design features. So these include weak privacy settings that allow teens to be contacted by strangers or added to large group chats. Anonymous designs that embolden harassers because people don't know who they are. And then also social quantification metrics. So these are like likes or follower counts. These reinforce public bullying by giving it more attention. There's also unwanted sexual solicitation, grooming, and sextortion. These can occur through social media or multiplayer video games. There was a study nationally representative in the US of young adults. They asked them about their experiences being sexually solicited online when they were younger, when they were children. Over 20% said they had been sexually solicited online as a child or teen. Over 10% had been threatened or coerced into sending sexual images. So this phenomenon of sextortion is unfortunately not super rare. 5% of middle and high school students in the US have reported it. And the rates of sextortion reports to the National Center for Missing and Exploited Children have been increasing since 2019. Then there's also child sexual abuse material, CSAM, or child sexual exploitation material, CSEM. These are associated with a lot of different psychological damage to victims. I'm going to focus on self-generated CSEM. So this is when minors create their own sexual photos, videos, or live streams. This has increased a lot. So 77% in 2020 compared to the year before, driven by an increase amongst 11 to 13-year-old girls. And so these are linked to a couple of design features that contribute to these harms. One is a research study from Stanford found that social media recommender systems, so just like Laura was talking about, where they kind of find out these kids and recommend them to adults, to predators, and they potentiate this harm. Other design features include, like I said before, weak privacy settings so that adults can be contacting kids, as well as the social quantification metrics. This makes children who are really looking to be more popular, they interpret likes and followers very concretely. They want to friend as many people as possible to have a stronger social status. And there was one study in the UK, children and teens reported that in order to get more engagement and validation through likes and followers, they posted more risky or shocking or attention-grabbing posts. And that puts them at higher risk of grooming because they're kind of standing out and being recommended to adults. So those are that's the data around these contact harms and how they're potentiated by designs. Next is privacy harms. So this involves data collection about minors and profiling them based on a number of different identifiers that you can make inferences about a child's age, their preferences, their purchasing details, how they respond to certain nudges to make a purchase or come back to the device. This sort of profiling can lead to several harms. I just talked about the profiling that leads to recommendations to predators, but there's also profiling that can lead to unfair video game practices. There's really sophisticated analyses that video game companies can do of player data, where they realize, what can I do to optimize the type and scheduling of purchase pressure? Meaning, if you're a teenager who loves to play video games at certain times of day, and you're more likely to make purchases at certain times or based on who you're playing with, or whether you just died in a game or those sorts of triggers, they can basically analyze which of those triggers is most likely to make you make a purchase, and then they offer that purchase right at that time. Profiling can also lead to targeted advertising for harmful or illegal activities for minors, such as alcohol, which can show up in social media ads, or gambling. Particularly for teens who follow sports accounts on social media, they are more likely to then be profiled and regularly see gambling ads. Okay, so that was the privacy harms. Now we'll talk briefly about harms to well-being. So these often stem from problematic and compulsive media use, sleep disruption, and negative social comparison. There are also content-related harms related to seeing self-harm material or other things that are recommended on algorithms. So let's talk about problematic, compulsive, and addictive-like use. This can be of digital media like video games, it could be social media, it could be internet searching. This is defined as use that impairs functioning, over which the user has no control, and which gets in the way of other daily activities. It's estimated to occur in 4 to 6% of children 5 to 9 years old, up to 19% of teens, and 9 to 11% of a college-age sample. And in a recent sample of 11 to 15-year-old girls, over a third stated that they feel addicted to social media. And it's far more common to hear teens saying they feel like they spend too much time online or on social media than they intended. So I'll talk about which designs contribute to that sort of compulsive or constant feel to need to be engaging online. But first I'll talk about sleep disruption because it follows the same mechanics. Sleep disruption is really, really common in US teens and children. Based on Center for Disease Control and Prevention data from 2021, 35% of children under 14 years have insufficient sleep, and 77% of US high schoolers do not sleep the recommended 8 to 10 hours overnight. Sleep is a really, really important part of mental health as well as bodily and physical health. And there's a large body of evidence that links longer digital media use and social media use and gaming to shorter sleep duration, later bedtimes, more overnight awakenings, and daytime sleepiness. So the designs that contribute to both compulsive use, prolonged use, and poor sleep include push notifications. So we have studied teenagers' phones and found that push notifications were delivered from social media platforms throughout the school day and often overnight. Teens point to other design features like infinite scroll, autoplay, algorithms trained to optimize engagement, ephemeral designs that, you know, you'll only be there for 24 hours. You have to go in there and look at it before it disappears. Impression and like counts. These are all mechanisms that teens say extend their use, make them afraid they're going to miss out on something if they don't go back and check, and make them feel compelled to return to media. And then it displaces other things they meant to do. Another harm is negative social comparison. This is something based on, you know, it could be based on popularity or appearance or happiness. Young people say this commonly occurs during their experiences on social media. Adults feel it too. But in young people, research suggests it may explain the associations between longer social media use and anxiety and depression. And Meta's internal research shows that design features can really contribute to negative social comparison. This could be an algorithm that trained on engagement, so it shows more trending accounts, like a celebrity or a beauty influencer. And it's also based on social quantification. So if you see that someone else has more likes than you or more followers than you, that can also contribute to this feeling of negative social comparison. So just to sum up, all of these designs work together. They are often tapping into child and teen developmental vulnerabilities, and they create pressure to engage with technology. They make it hard to disengage, and they often worsen minors' experiences online. Through my work with the Center of Excellence, as well as with my research, I hear repeatedly from parents, from academics, from other experts that tech needs to change to improve children and teens' mental health, rather than expecting all of the burden to fall on children and families. So that's why I really appreciate you considering S69, because it's an essential part of that shift to make this a healthier digital ecosystem. So thank you. I'm happy to answer questions.
Thank you. Really appreciate you being here and working with our schedule. Do we have questions? I got just a question about obviously this is legislation of this type is challenging in our country. Are you aware of other legislation in other places that has been effective?
There is legislation in the United Kingdom and the European Union that has focused on some of these same mechanisms. The data profiling is part of the age-appropriate design code in the UK, which has been successfully implemented. And actually, the summer before it went into effect was when you had a lot of design changes happening at Instagram and TikTok and YouTube, where they changed some of their notifications or they made teen accounts private by default. So I think that's evidence right away that when you implement a design code, you can get the platforms to change their default designs. There's been, you know, I act as an expert witness for the California Age Appropriate Design Code also. So I have been following, you know, I'm not a lawyer, so I can't speak to exactly which parts have survived the challenges to the First Amendment or other parts of the constitutionality of laws like this. But what I've heard consistently from policymakers I work with is that if we can focus more on design and product liability, that this is a design feature that increases the risk or likelihood of harm, that's going to be much more likely to be successful than something that's only talking about constraining content, which is more about free speech. So that's helpful, but I think it's a pretty dynamic process right now in the United States, figuring out what's going to be the best mix of protections.
That is helpful, thank you. And we are focusing on design, as you know. Okay, let's chance for questions now. All right, thank you very, very
Okay,
much.
thank
Oh,
you.
and if you could send us, if you have a chance to include your written testimony, that would be wonderful.
Will do.
Thank you.
Thank you.
Okay. So right on time, our intrepid ledge council.
I thought you had one more witness. No.
No, we're gonna need to reschedule her for tomorrow.
Take precedent over everything.
I don't know.
We move things
That shouldn't be.
just for you. You know,
I appreciate it.
you're like Moses, you come in and
Wow.
it's just like parting the Red Sea.
My,
Wow.
my head won't fit that door when I leave. All right, well,
Okay, and I have not yet shared. Maybe on folks' desk.
okay, let's make it a
the,
Zoom.
the amendment.
Yeah, you should all have a copy of it.
Do we have a copy of the amendment?
No, can I get a Zoom link?
Oh,
Yeah.
sorry.
For some reason, it's not in the email. Thank you.
Bye.
Do I have it? Yes, I do. Okay. There's a one-page amendment. Did you want to copy? I think that's it. Yeah.
I've run on 6 times since you walked in, so
Next time. Okay, well, you could do it backwards.
I know.
So should we jump right to the amendment? Rick, do you have, that's,
It's up to you, Madam Chair, how you wish to proceed. I can start with that, or if there's questions the committee has about the testimony.
let's start with the amendment and then we'll, because I think that is in response to many questions and concerns that have come up. And then, I don't know if you heard the testimony from Chris Delia. So he will be sending some suggested language that would rectify the problems that he sees in the bill. Obviously, I don't know if you would see the similar problems, but we will have other language.
And he reached out before as well, and he sent me this morning, some
Okay.
language that I think you referred to. So Rick Sagel, Office of Legislative Counsel, it's good to see you all again. So in front of you and on the screen now is a proposed committee amendment to S69. And this is kind of in response to some of the concern that small businesses in Vermont might be caught up in the regulatory red tape that this bill would cause. So it's pretty simple. We are really just adding an exemption to the bill. So if you look, this is called an instance of amendment, instead of a strike all, it's just replacing one part of the bill. So what we're doing is section 1, 9 VSA not 2449B, which you have the bills introduced on your screen or on paper. That is on page 13, line 10, where it starts exclusions. So the bill currently has 5 exclusions. And by the way, 5A is already part of the bill, the journalist exemption, excuse me. So we're adding B as the new language. B is the only new language here. An entity who controlled or processed the personal data of not more than 100,000 consumers in the previous calendar year. And this excludes personal data controlled or processed solely for the purpose of completing a payment transaction. You're probably going to ask me how many Vermont businesses transact or process more than 100,000 consumers. I don't know. This is I think, fairly high number to eliminate the small companies that may have been caught up in this legislation that you don't want to have to deal with the red tape of this bill. But it's a suggestion, and I think the committee can discuss if that's the correct number or if that's even a correct thing to exempt.
Okay, and this, so the idea is 100,000 consumers is a very high number. And if there are folks who are making video games, for example, I don't want to say there's social media companies in Vermont, there may be, but if there are such companies, if they have fewer than 100,000 consumers, and consumers are children in this case, right?
And no, it's
Okay, then-
it's a Vermont
Okay, so
resident.
any Vermont resident, but who is a consumer of that?
So consumers defined as a Vermont resident.
Okay.
Includes minors and adults.
Okay, so, but if they have data on fewer than 100,000 consumers, they would not be impacted
Correct.
by this bill. I just want to say, if there are folks with fewer consumers who are causing these harms, we should find a way in the future, if this does go forward, to stopping that. I mean, we want to stop the harm. But my understanding is we believe that there are not those folks in Vermont.
Yeah, and this means companies that control or process 100,000 Vermonters. So 1/6 of the state,
Right, which is a huge, large.
which is a lot.
Yes,
And that would limit it to relatively few companies, it would seem. If that was the intention, because consumers defined as a Vermont resident.
Yeah, you're gonna miss a lot of businesses that may or may not harm, whatever their business is. So that the number is a suggestion. That's what the committee can talk about, if it should be higher or lower. But yes, you will include some of the larger companies that have that many Vermonters. You can kind of think about who those companies would be. Or you could change that, but then maybe lump in some businesses that you don't want to include.
right. Just from my, the testimony so far has been all focused on the large businesses. In explaining the harm, I haven't heard any testimony
Yeah,
about harms from small businesses.
this would significantly, probably can't imagine any Vermont company would does that. Who knows?
Well, frankly, I'm not even just concerned about Vermont companies. I'm also just concerned about any company that's not a social media company. We're only talking about social media companies here. So even if it's not a Vermont company, if it's a company operating elsewhere, we're not looking at them. We're looking at the social media companies specifically. That's the intent of the.
That's the intent of the social media and similar, and it's when the and similar that
Yeah,
where it gets.
what do you mean by unsimilar?
Right. Why can't we just get rid of similar? Why can't we just say social media? If the social media is the demon here, why can't we just say this is social media?
That's a legal question.
Well, I don't know what the true legal customer is, social media.
It is social media, correct?
So in other states that have limited it to social media companies, based on research I did, those laws have been successfully challenged. Those specifically singling out speech of certain companies.
But you guys can prove the harm. That's what everybody says. We can prove the harm. We can prove the harm that you're doing. So therefore, we can sustain any challenge. It's social media that we're after. Say social media, and then let their chips wherever they go, wherever they fall.
I'd also, just because she mentioned, and I hate to do this, Sam, but sometimes I have to defer to you because you know quite a bit more about this than I do. Yes, it is. It absolutely is. Yeah. Gaming systems that she talks about, would that be, do you think that could be included in this as well? I just because my lack of knowledge.
Can you repeat the question?
So would you include with social media company? If she included when the Dr. Radesky was giving her testimony, she included gaming systems as well. Because she was just not talking about social media, she included gaming systems, so,
In my opinion, on this topic, yes, video games certainly can be addictive, but I would argue that social media is by far the greater harm. And social media, in essence, I mean, when Facebook was one of the big pioneers in that industry, it was intended as a way to be able to keep up with your family,
Right,
keep up with your friends, see the photo of their dog, whereas, video games are intended to be entertainment, they're intended to be relaxing, but social media is kind of gone a little bit further than its original intended use, whereas video games still have its intended use of relaxation and entertainment. And while yes, video game addictions are common enough, I would say social media addictions are pretty ubiquitous, more than the video game addictions are. So I actually have an amendment to the amendment language to exclude video game companies, because it's a huge industry, and a lot of the owners do not want to see their video game access yanked because Steam is afraid of being sued in Vermont or something. So
Great, so do you have that language?
yeah, and it's the back of the napkin language. It's not the illustrious Rick Sagal. It's like
What's going on there?
not that wrong. It just adds a C entity
Senator
under
exemption.
5. Yeah. So
So let me ask you a question. So if it sounds like there are some video games who do have components, especially the
Wow.
sports ones.
well,
So how would we address those harms?
I would actually push back on you a little bit. I wouldn't say video games are designed to be addictive. Video games are designed to be fun. They're designed to entertain. And as a byproduct of that, those design features, which are not intended to be addictive. I don't think any video game company on the planet, now maybe that's not true, but I would say most video game designers do not design their products to be addictive. They design them to be fun, because that's their business. If something's fun, people will buy it. With social media companies and what we're talking about with this bill is they're trying to keep people on the app scrolling. They're trying to keep people there because they're delivering advertisements, which are an ongoing source
Right.
of revenue. Once somebody has bought the game, they've already bought it. They own it. So the businesses they've already made their money. They're not going to make extra money by keeping people on the game.
Most games right now are not like that at all. They are subscription services where I get it for free basically, and then you play. And what we heard was you play and they process your data to figure out the exact time to push something to you to buy coins or whatever.
Right.
So
What games are you referring to?
I don't know, because I don't play them.
Okay.
I'm guessing it's Fortnite, I'm guessing it's Roblox, I'm guessing that probably Marvel's Rivals, and these are the games that I'm watching my son play.
okay, I was about to say, you,
And that's
we're
why
not
I
playing,
know
we
about them.
you know a lot.
That's why I know about them, but I know he's not buying anything. I don't know if he's being bombarded with.
I mean, I do not play those games specifically. And those games I would say are addictive, but I wouldn't say they're addictive because of the design of the games. I'd say they're addictive because all their friends play them. Everybody plays them. Influencers on social media are pushing them heavily. They're everywhere. And then also just they're very fast paced. They're and
It's specifically targeting them.
I don't know if those games even include those features.
Yeah, the doctor did talk about this.
So I have a suggestion.
Yes.
Is the video game concern just with the compulsive use duty of care element, or are there other elements that you don't want video games to apply to?
My concern is that it's going to make video games companies liable to lawsuits when they're not actually trying to addict kids.
Right.
All they're trying to do is make an entertaining product like a book or a movie, but books and movies aren't intended to be addictive.
But is that the main concern, is the compulsive element? Like, because there's a lot in there that deals with discrimination, that deals with, you know.
I would say compulsive, and then was it foreseeable harm?
Emotional distress.
Emotional distress. Yeah, thank you very much.
Yeah, you
Because horror games can be argued that's emotional distress. You know, and
But that would be the content.
yeah.
Which is excluded.
So something,
okay.
something committee can discuss is you can make, you know, low level exceptions for, you know, this definition of video games. You could say, you know, not that they're exempt from the entire bill, but you could say, you know, reasonably foreseeable compulsive use of online service, except, you know, video games shall not be held to this specific element. Just something to consider. You could give them the entire exemption, which is easy. That's what you see on the screen here for the controllers who have less than 100,000 consumers in their database. However, you can also do it more with a, you know, a tool. Let's say here, this. Something to consider.
Well, and we do say social media platform does not mean like.
Right, but
That is,
That definition of social media is not included in specific portions of the bill.
right.
but, we talked about that.
The minimum duty of
Yeah,
care applies
okay.
to all covered businesses.
Okay,
But yeah, social media platforms have their own little section, and video games do not apply there, but they do apply to the rest of the.
I see,
They are,
okay,
yeah.
right.
Something to think about.
Okay. And then we're also gonna have the amendment possibly for, the banking industry.
So that's. If that's something anyone wants to go move forward with, I can certainly put that in the next.
Did you see the
Sure.
testimony at all?
That's all of it.
Okay, it was basically that the requirement to have a parent approve would mean that the parents wouldn't have, or the parents' data would be unreasonable. No, is that you probably say that.
He's also worried about the federal regulations.
Right,
That
Yeah.
banks already have to abide by in their data. They have to keep data longer than other places. And I understand that's a federal issue. So again, you can go the entire exemption and say financial institutions. I forget the Vermont statute that.
Yeah, he had mentioned it.
Okay.
He basically talked about, you know, the heavily regulated industries that already are doing everything that we're asking for here, essentially. Except they have other regulations that might,
Right.
like, so that, healthcare, banking, insurance, were the three that we had mentioned. And to some degree, that sort of exemption makes sense. If they're already heavily regulated to a degree that it covers everything that we want, then they shouldn't have to worry about figuring out if their policies important this.
I think he's mostly concerned about the data stuff.
Well-
Because they're not making apps that are addictive. They're, you know, they're worried about keeping the personal data
yeah,
of consumers.
he was worried about that, but also a couple of other things where, the URL, the, physical location, they use
Tracking.
to, check for fraud. And so
Oh,
he's
right.
concerned they wouldn't be able to do that.
Push notifications.
And,
Push notifications.
and that,
Okay.
yeah, they have fraud alerts sometimes at night, so.
Yeah.
I doubt that the fraud alerts are keeping the teenagers addicted, but,
Yeah,
so
same thing.
those are his concerns,
So would you want to give them a entire exemption
Yeah.
for the bill?
probably.
The way he was describing it sounds like that's all there, and I don't know if you'd be able to do this, Rick, but find out if the insurance regulations are essentially the same. Because we have health in there to begin with,
Right.
we just don't have banking, or insurance.
It'd be easier to tell who you're going to include versus restricting.
My concern about having exemptions that are really well known is that basically anyone can be sued right now for all of these things. And so the anxiety of a business, you know, being, you know, am I going to be sued? Do I have to do this? Is already there. And we don't want to miss the predators. So my preference is, you know, we already know that the industry's keeping kids safe because of the regulations. Great. We don't know. I'm going to err on the side of making sure my kids are not anxious and worry a little bit less about businesses being anxious about lawyers. But that might be because I'm a lawyer and you know I'm not that.
It's also gonna do a bill that isn't going to get challenged in court or get vetoed.
Well, the veto is a political thing.
Right.
Everything's gonna be challenged in court. This is going to be challenged in court. And I think that this is pretty strong in terms of that. But I'm also not an expert in terms of that sort of law. I really do think that everything that the state legislature does is going to be examined by court. Every law that we pass is going to be examined by court. And that's why we have an AG.
Well, I think everything has the potential to be. I think this has the absolute certainty to be.
But why? No one has said this is why it's going to.
You won't even get to the attorneys. Attorney General Clark wouldn't even talk about it.
Right, she wouldn't do it because
Because
she
knows.
would be defending.
She knows it's gonna get, that's why she wouldn't even talk about it. If she didn't think it was going to be, she would say, well, here we go, here we go, here we go. She knows this is going to be.
If there's someone can say this is specifically the thing that's unconstitutional, then I will buy that and I will be like, okay, let's fix it. But no one has said.
You asked about the certainty. I think precedent, every state that has done this, it's being challenged. So I mean, I think we need to do it but I do think we need to narrow it. And I also, think that, just expect it's going to, every bill that has come out that concerns data privacy is going to be in the court. They're just, I mean, every single one. So just expect it. I think we need to have it. And then,
So
and then you make money. You lawyers make money.
I know. I'm a
So you're in it.
No, I'm actually technically a county employee.
Oh, I'm sorry.
I don't either. No.
I'll work.
No, they don't.
But even with all, we've heard that it's been challenged in all of these other states. No one has said it's been challenged because of the specific thing that ties into our bill. And I think they would if they could, but they're not. So,
Well, regardless if they say that what the specific thing is, they're going to challenge it.
oh yeah, that's
Yeah.
that's a given. That's a given.
So,
But if they were going to point out something that is actually fatally flawed in this, they would.
and if, and I'm not Lord, but I would challenge everything. So like, I guess to my point is, try to, and yes, does it do everything that we necessarily want? Probably not, but what's the old saying? We take the good as far as
Don't make the perfect.
yeah, all of that, all of that. So we narrow it.
Yeah.
We exclude all the businesses, whether we say it's social media, yes, you're right. It has been challenged, but we know it's gonna be challenged anyway. So in my opinion, we narrow it to social media because that's the driver of what we're talking about. And then, and I think, and remember, this has to get passed, so we do that. I think this gets passed. And I think also it's less likely to be vetoed, and I don't want to be here in the summer. I like my summers.
No, you're in an aquatic center, so
I'm sorry?
you're in an aquatic center.
Yeah,
So,
my God.
well, and my other question is, I wish Todd was here, but how expensive is it if this is gonna get challenged? Like, what are the resources for the Attorney General's office here in Vermont? Like, how much would this cost the taxpayers if this is gonna be slogged for the courts? Like, I don't know.
Yeah, I'll do that.
Yeah.
Well, we can ask him to come tomorrow.
Yeah.
We just heard
And-
for half fiscal year,
Yeah.
it's going to cost $50,000.
And we balance that with the harm to the children.
So, yeah, that's my compromise on this. We narrow it.
Am I hearing a different amendment?
I just think, I don't even know if we need to amend that. I think we can just agree to, we need an amendment or whatever, but. If this thing got down to social media. Then you start to get my attention.
I mean, covered business, is that
Yeah.
I mean, that's defined, pretty broad.
Right.
So we'd be sticking something in there to,
You basically, this is just me off the top of my head, we define social media platform right here. You basically change cover business to a social media platform. And just, you wouldn't need all these exemptions.
Right.
You just have that, that's, now, let me add one thing, there is a catch-22, the more you narrow. The more challenging it is.
Okay.
To some extent, I understand the wanting to target this, but courts don't like that. Courts don't like targeting bills, obviously not just to the person, you can't do that.
you're right.
Yeah, but nor should you do that to companies, businesses. Just because they're big doesn't mean they do more harm than
I
a
think-
small social media company that does harm per capita, right? To a similar extent as a large social media company. That's just what the argument is gonna be from.
Well, I think you get rid of the 100,000 consumers. I think you say social media companies. I mean, we're targeting it, when we.
We're targeting a service.
Yeah.
We're not targeting even specific businesses, because it's not like the big businesses are the only businesses. And these sort of like, a different one comes all the time. I mean, there's one called, I don't know, what's called The Truth. I mean, that would be one, presumably. But that's Twitter that turned into X. So these things change all the time. So it's a service that I think is fairly well defined in there, and not an actual, group of company. Because they'll be coming in and out of existence anyways. I want to put that on the record to make it clear that we're actually targeting these big firms.
And I'll be honest with you, I want this to get out of committee, as well. I mean, we're never all gonna, in anything that we do, have consensus on stuff, but I'd like to, try to get it out of here, get it on the floor, and not have to be there. That's just me.
I agree. I want that too. I think we should have the AG's office in tomorrow to advise us along with you. Does that make sense?
Yeah, that's fine with me.
Yeah.
Do you have it scheduled to?
No.
Todd. I emailed Todd, last night, he said he'd get back to me, so I'm not the schedule, that's your purview.
Okay. Right, but they're aware. And I didn't take, the Attorney General's, not hesitation, but not speaking specifically about this, because that office has to defend it. So they can't, there's certain things they can't say in advance, but my understanding is that they are supportive to the extent they can be supportive. And I think that needs to be
Yeah,
clear.
it has to be read through that to be like, yeah, we think that we defend it.
But I think that actually has, we can.
Yeah,
Yeah.
I mean, that's important to know, so.
And Rick, before I forget, HIPAA is not defined in our bill. It was in the privacy bill,
Okay,
so I think we do need to just add that one,
thank you.
definition.
Yeah, at least spell it out, right?
Yeah.
All right, so we'll have, there is one more person who would testify. And she would testify on the legalities, actually. So we can have that testimony and you, and we can get the AG in tomorrow.
So what am I burning for tomorrow, Madam Chair?
Well, let's talk more about this.
Just so I have a,
You can rip.
Yeah,
you don't need a copy of it.
No. And again,
Thanks for bringing it up.
yeah, and again, my biggest position is that there's so many video games that once you make it, the consumer buys it, that's the end of the story. It's there for entertainment,
Well,
and I would say that's the majority of the industry.
I do agree a little bit. Probably more than a little bit. In Center Pocket, that it's not quite that simple. Some of them are. And maybe the ones that you play, but there are a lot of ones that are interactive.
I'm aware, but I would say the majority of the games on the market our intent for entertainment, not for addictive.
I think that if you wanted to do what you both would want to do as far as on that, you could say ones that aren't actively on the internet as you're playing.
Also,
And that would be a very, very easy thing to do. So I hear what you're saying. So like buying the book, I'm buying a book. Who's bothering me while I'm buying the book? Or I'm playing the video game. I'm not connected to the internet. I'm just plugged in. I'm playing my video game. Nobody's bothering me. But I also see Senator Plunkett saying, because there is interactiveness where you are engaged and you are online and you're playing, and then there are chances for them to be bothering.
And Senator Douglas, I don't know if this,
usually just call him Sandy.
now I know, they're trying to use the whole senator thing.
Mhm.
Yeah,
The first song committee is going to have a lot of flags to bring up.
Okay, so why don't we do that? Or get
yeah,
yours.
just thing, so compulsive use. So the minimum duty of care regarding compulsive use, reasonably foreseeable compulsive use of the online service product. So it has to be an online service product in order to fall under the compulsive use duty of care, which would take out most, standalone video games. Really.
Right. But I hear your argument there. I would have to just think about it a little.
No, yeah,
But I can see your.
I just point that out because maybe that solves that. Maybe the.
So are you saying that the video game would not be an online service product feature?
If it's the video games that Senator Douglas seems to be talking about are just the ones that would be standalone games that wouldn't necessarily be interactive with anybody else.
Also, I have another point to bring up. The covered business. So we're talking, the businesses are the ones that have the standard of care, like Meta or Facebook. They're the ones that they design the app, they have the app, and they're the ones that we're targeting. But then look at Steam. Steam doesn't make the games, but they're the covered business. They're the business that's selling the game. So is it the manufacturer of the video game, or is it would be the one that's selling the video game? Because they're selling it. They have a massive library of millions of games.
So the ways to find is whose online product service features are reasonably likely to exit by a minor. It's not necessarily who makes it. It's who offers it available to the public. So it could be the last, entity to offer that service to the consumer, which would be Steam in this case.
They're the best example I can use.
Yeah, that's a good example.
Yeah, that's.
Okay, why don't we go through this?
Yeah, we can put tag in that. So page 17 of my copy here.
17.
Page 17, sir.
Okay.
For transparency, so covered business shall prominently. What is the definition of prominently? Like, what's the thing there? Because as it is going down here, privacy information, terms of service, policy, community standards. Those, if you scroll down to the bottom of Facebook, those are all generally listed there at the bottom. But is that prominently?
Dictionary definition.
Yeah. So
It would be the dictionary definition.
Okay.
Yeah, when a word isn't, sorry, I might be stealing your stuff here. When a word isn't defined in statute, you literally look at the dictionary. So it's the common understanding of the word is.
Right.
And Scalia, I forget what dictionary they would look for, but he was the one that I actually learned that from.
Like personally?
Not that's technically.
Yeah, so I kind of worry about that a little bit. And I wonder if we'd be able to remove that, because I think clearly provided on our website and mobile application, I think the word clearly is a little bit, it's still clear. The word clear is still clear, but it's vague enough that that I think it still would allow the disclaimers and all the other information to still be in another spot. That's not, if you remember from the Hitchhiker's Guide to the Galaxy, the information about blowing up the Earth was hidden in the bottom drawer in the basement of the building,
And
So-
on Alpha Centauri.
Yeah, exactly.
Yeah.
So That's not what I'm looking for. I'm just looking for, when it comes to transparency.
You know what they're talking about?
I've heard of it, I've not
Okay.
read it or watched it.
No, it's classic
Yeah.
and it's
Yeah.
so, it's,
And so that's not what I'm looking for, to provide a loophole for the company to let the information be buried. That's not what I'm looking for. I'm looking for it so it's not going to, require it to just have a big pop-up when you open the website that you have to have all the information. So I wonder if removing the word prominently would be okay. And just have it clearly provide. And then also on section 2 there, same page. So and then, again, this is a question, but I kind of wish though we had a lobbyist for Meta or one of the other organizations here.
gosh.
Um,
We can grant that wish, but
yeah, well, just like to ask some of the questions
Yeah.
is
no, it'd be
they could
helpful if
provide
they
information.
would answer.
Yeah, so section 2 there, is that proprietary information should we require businesses to disclose software like that? That's just a question that I have. So, I have my color code flags. That's just a question.
Yeah, I had that highlighted too.
We could put it in here, don't think there's trade secret information in here.
Okay.
But you could have a, limitation. Let's see.
I think this is
You could add-
really important and just remember, this is gonna go to other committees and, they'll have a shot at it too. I think that's really important. That's part of the fundamentals of what we're trying to regulate.
Yeah, and then page 19, so section 3, I don't know if it's pertinent to exclude parents or guardians from being able to view all that stuff, because a lot of the protections that we have for the minors is the minor can turn off those protections at any time. So if a minor wants to, under the bill, they can turn off their protections. They can be contacted by predators or any of the people that were trying to keep away from the minors. The minors can open the door and then the parents aren't allowed to see who walks through the door. It is if you go on putting
I
down.
think so, yeah.
Yeah, so it prevents the parents from being able to monitor their kids, and if their kid makes a decision to open that door, then parents can't see who they're talking to if they're choosing to talk to people. And so honestly, excluding parents and guardians, that could be protecting sexual predators, that could be protecting any predator on the internet, from the parents being able to see them. So
Yeah, we talked about that a lot last year.
So there would be a signal. It wouldn't prevent the, parent from observing the child. There would be a signal, a conspicuous signal.
It's a prominent conspicuous.
Like without
Online
providing a
space.
conspicuous,
Yes.
so the minor would know that they
Yes.
were being tracked. Would they know that they were being tracked by the parent? I don't know. It
Any,
doesn't say.
any
that.
consumer,
Just
any
anybody.
consumer, yeah.
The little thing on my iPhone.
When you share.
At the top, there's an arrow that tells me something reading what my location is. I'm going to check the weather.
Oh, so it doesn't, so I suppose maybe I read that wrong. So it would allow a parent or guardian to observe, but the minor would know that they're being, okay, right, okay. That can include that. Right. And then page 20, yeah, so here's a question that I had. When it comes to the rulemaking section for the Attorney General, and obviously I know that we discussed this a little bit last time that you were in here about having it in statute, but giving that discretion to the Attorney General. Do we want that discretion going to the Attorney General, or do we want to have that going to somewhere in AHS? Because you're talking here about design practices leading to compulsive use, and while I presume the Attorney General is very, very intelligent, not necessarily in depthly, not fine tuned for mental health and addiction. That's not really the Attorney General's wheelhouse, is being knowledgeable about addictive, practices or anything like that. So I wonder if roping in, the agencies that deal with addictions and deal with minors, and so I wonder if that would be more prudent.
Great question. And my understanding is that the Attorney General's office has embedded attorneys in all of our departments. So they may very well have someone embedded in that, but let's ask them when they come.
Do you think it would be prudent to put in language, a provision that they should coordinate with the AHS to some degree? Just instead of just leaving it up to their discretion.
So the rulemaking process is really comprehensive. Where it requires public hearing, requires public input. I'm not sure if it actually requires, but agencies give feedback to essentially every public comment. And the Attorney General's office does have, I don't want to say access, but sort of connections with everything that could be important for that. So at least lawyer me, is comfortable with the rulemaking process on that. But it can't hurt to send a clear signal in the statute that we want to make sure you're considering this and this, in governance. I think I'm comfortable with the Attorney General. But I think sending the signal you want is very good idea.
So then what sort of language do you think you could write a very short sentence of the Attorney General shall work with or coordinate agency human services?
Do you want it to
Or
be specifically the Department of Mental Health? Or
Yeah, DMH is probably fine. Yeah.
is HS?
It's
It's a ton underneath it.
well, I suppose
It includes DCF.
So if you went through AHS and then kind of figure out who's the best to do it, but you could just do DMH. That would be sufficient in my eyes. So
The only concern I have on that is there are other agencies who, law enforcement, the digital services, I don't want specifying one agency to mean that the other agencies are less
Right.
important, and I don't want to try to be complete because we'll never know. They might need to.
I don't think that would limit them to only working with DMH or whomever, or lessen that. But I think it would be more, it'd give greater specificity to the Attorney General in ensuring that their guidelines and their rules around design practices leading to compulsive use are going to follow appropriate science appropriate you know what I'm saying?
Right.
You know what I'm saying?
Right, but there might be other authority too. But yes, good idea. Let's talk to them tomorrow about that.
And then I have one more. Well, stop.
No, don't. There's, we need to
This is actually. the
be
concept.
thorough. Yeah.
Last page, the effective date. So Net Choice was very clear. I think it was very clear in their recommendation. Well, one, that this whole thing could be a study, or alternatively, and I think is a little bit more of a compromising view instead of just making a study, is pushing out the effective date. Because all those cases that are still ongoing, they could come out and the ruling could be unconstitutional. And then we have unconstitutional law statutes on the books. So my question is pushing out the effective date something that we can do?
So if we change, it wouldn't change the constitutionality. So if you had even like 2028, let's throw it out there, you would still have to act to do that.
Yeah.
That may not be easy. Just kind of giving you advice. You can say something's unconstitutional, but you'd actually have to take off the books to remove the enforcement of it. Of course, I'm not sure if the state would enforce a unconstitutional law. That would be in the federal level, the state level, right? That also depends, like which state hasn't been unconstitutional.
So then I suppose I have questions about exactly what would be the what's the narrative once, if this was passed and the governor signs it, or it goes into effect, or and it gets passed, and let's say the effective date is 2028, is it going to be immediately challenged, an injunction, and then it's floating in limbo? I'm not a lawyer, so the exact procedure of how that would take before 2028 and when the courts in other states will come up with their decisions, when would we be able to, through legislative action, take it off the books?
It could be challenged upon signature. It becomes an act. It just does not become effective until July 1st, whatever date you will choose. But also keep in mind, it could be challenged here, right? This specific law could be challenged, okay? But another state's law that is challenged, in fact, these have been challenged, right? California's been challenged, so forth. They may not match Vermont's law specifically. Like I told you last time, this is kind of a Franken law, right? This is taking some of the things that worked in other states, trying to come up with a solution. So just because California's, New York's, Maryland's is deemed unconstitutional, wouldn't mean that a judge here would find this unconstitutional. So I'm trying to answer your question as far as it wouldn't, they're not all equal. And so if you think something is going to be challenged, the effective date's not going to matter. And once it's signed by the governor, it can be challenged immediately.
Okay.
I hope that made things easier, not more confusing.
Jury's still out.
Okay, all right.
And what Rick had said as well is that, let's just say hypothetically, federal constitution, it's held to be completely unconstitutional. It's not going to be enforced anymore. So there will be the sort of out with things. Although it's all state, they're all,
These are all state.
I'm gonna retract everything I just said.
Well,
Well, there could be federal law.
But-
They said the Senate passed it.
and sometimes the state
Yes.
won't take a law off, and then a federal law changes and the state law is in effect again.
That could happen.
I mean, that has happened. And we do have a process where we clean up our laws in different sections of the law. We'll do it. We'll do a massive cleanup of things that we don't want anymore. But I think that we have left some stuff on intentionally.
Well, abortion was illegal for a long time.
Right. But there were, and so there were state laws that weren't in effect with, but with the federal law changing, and now they are in effect.
Yep.
Okay. It's been interesting.
Yeah, the purple one is just getting past the definitions.
Oh,
It's empty.
oh, yeah, I know. It is a lot of definitions. All right. So
Direction for tomorrow. I can be given some.
Yes.
What would the committee like to see
Yeah.
tomorrow?
I think we should keep this one, the 100,000 customers. We have the video games conversation, which we mostly, I don't think we got to a good point on that.
I think it was mostly settled. The concern that Senator Ponte has is games that have like digital transactions.
Subscriptions too, right?
Well, I don't know if you could argue that subscription model is addictive.
Right,
I
guess,
that's a method of payment.
okay, but I'm sorry, I misspoke. So when you're in the game, your character dies, you can buy something to help your character live again. I mean, there's those. And then,
I played Tiger Woods golf, so I guess.
No one dies.
That's-
No one died. Unless you hit the one.
Unless you miss a pot.
Yeah. Yeah, you hit
Then we all die.
You know, you hit someone in the head with
You play high stakes.
you know.
Tiger Woods.
probably has gambling, actually.
So an amendment to exclude video games? Is that what?
Yeah.
And for the entire bill or just for that compulsive use and
Emotional distress.
emotional distress? Sorry.
I mean, that's basically the entire bill. I mean, that's the intent of it, is that it's,
There's a lot more. I mean, I don't want to.
yeah.
It's a big portion of it. That's maybe the wider net that we're catching, but
Yeah.
there's a lot in here that you that the video games would still need to abide by, is you just gave them those limited exceptions.
Right.
So it's a very important decision if you want to make that, just like with the financial institutions and with the consumers, number of consumers processing, that's a big exemption to make.
And it's the data for children too.
Yeah, the bill
I mean,
includes
that's really
how
important,
you process handle.
Right. right? And just what we heard today, and we've heard before, but what we heard today about intentionally selling minors data, whether you're sending them the actual, person's data, or whether you're just sending the person themselves to the harmful individual, that's pretty bad. And that
Yeah,
we
I
need
would
to,
say it's just the compulsive use and the foreseeable harm, because when you look at the default privacy settings, I do think it is more prudent to make sure that kids aren't getting contacted by predators when they're found by Roblox.
However,
However,
these are social media platforms in this section, so the video company will not be.
right, okay, so never mind. Then.
I
Scrap that.
I don't want to keep
Strike through.
okay,
You know.
but you do want the compulsive use.
Yeah,
exception.
compulsive use and foreseeable harm exemption. Just I see somewhere a well-meaning parent getting angry because their kid got scared because they saw a horror game or something like that, and it wasn't the company's intention to scare their kids. They're making a product for people that like horror games.
I don't want, but do we want an amendment to have covered business redefined as a business that provides a social media platform service? We'll discuss.
That's for the committee.
That's what I'm at.
I think that makes sense. I think that really dials. I think that dials on the intent.
I agree.
well, and that's what I've been saying all along, but then I'm getting advice that wouldn't be a good way.
Kind of equalized.
Yeah.
It's almost certain to fail. It's up to the committee. I know the law's gonna get challenged. It is wholly your choice, but I just, based on court decisions, that is almost certain to fail. Because you are targeting, and I can bring the case law tomorrow to show you all.
Yeah, can you share?
Yeah, I'm glad, I'll email it, so you all have it, and we can talk about it tomorrow. And also, I'll draft it, so you have that as an option, but just want to put that out there, that's, there's already a precedent that can't be done. So that's even more so than it is, but
Yeah,
maybe
Just so we can
Yeah.
see it, just so we're
yeah.
more informed on.
sure,
and can you put all of that in one amendment?
it's gonna be a strike all at this point.
Oh, really?
Yeah, I can't,
I hate
yeah.
strike.
The social media thing is a strike all. Okay, I can do one amendment that has Senator Douglas's exceptions for video games. That'll be in addition to this, I took my screen off, but it'll be a couple more amendments targeted, but then the social media one will be a strike all. And I can have that kind of prepared for another time, in general, but I can have that prepared so we can be prepared to, have a vote either way.
Okay,
Would it be enough to just change the definition of covered business?
I think it may be, I hope, but I have to kind of go in there and see I'm not missing anything. Because the whole bill is based on covered businesses. And if I can find them as a social media platform, it may just be that easy, but I don't want to give myself that,
oh, but actually, that's the one that we likely won't propose, because you're going to tell us that it won't.
But you all can disagree, right?
Right.
That's the beauty of this. You can say, right,
But-
wrong.
But that's the one that's a strike.
Yes.
Yeah.
But I still
Yeah, I just
prepared that
don't want to
one.
waste.
You have several members of your committee who like it as an option, so I didn't
Yeah.
want to, give you that
All right,
option
okay,
in case.
if you can do it.
I had
You can do anything.
several.
That's-
This is what you had planned for me. You wanted to build me up and then just give me all this work and
You guys don't use the work the usual state hours, do you? You don't.
not this time, well, this time of year, that's all.
And they know that.
Yeah.
Okay, all right, so you have what you need.
I think so. Couple of the financial institution.
Yeah.
Exception
Uh-huh.
that Chris brought, for his last name, Delia,
Delia, yeah.
brought, Senator Douglas's.
He's emailed us, right? Chris has emailed us.
We did get it
Yeah.
now.
But I think he's going to have additional. He sent you an email today, this morning, he said,
I think-
but then he was going to send another one.
Okay, I'll look at my email after this.
Okay.
And then Senator Douglas's addition for the video game exception. That'll be in addition to the 100,000 consumer exception.
Yeah, he should email us that, when you email. Just
I see, okay, I see it here.
Yeah, just barely,
All right, good.
48.
And we'll have one more witness. If you have any other witnesses, let me know. It really is last call now. But good, I think we're getting somebody. Are we good? Everybody good?
Good.
Okay.
It's a trash, nothing, it's easy, like, it's a new one.